Good morning, thank you. My name is Susan Scan. I am an attorney in Las Vegas. I've been practicing civil law here for 33 years. I moved here in 1976 to take a job with Jones, Bell, Close & Brown and have practiced continuously since that time. I was raised in Salt Lake City, got my undergraduate degree at the University of Washington in Seattle, then I moved to Hawaii for a couple of years. I was rained out in Seattle. And I went to law school at Cal Western in San Diego. There are a number of Cal Western grads in town, and that's actually the reason that I'm here. I think I interviewed in a number of places and found that the hospitality and the small townness of Las Vegas was wonderful. The legal community here was very supportive. So I have found this to be a terrific community. I met my husband here. He's a musician. He was in the house band at Caesars at the time that I met him. And I got to travel with him to Japan with Frank Sinatra and do a lot of fun things. And having somebody with a very different profession that you're married to is, I think, gives you a good perspective on life. I have two children. They're both in their 20s now. And I've been practicing 33 years. One of the reasons that I didn't, in fact, the primary reason that I did not run until as long as I have is the children were at home, and that's what time and energy that I had was raising the children. I felt that that was important with my law practice. That took up all of my time. I feel I'm very well qualified for the office that I seek because it is a civil seat. It is funded by the filing fees and it is dedicated to being civil for at least the initial term. I've been handling commercial litigation, bankruptcy matters. Our firm concentrates on real estate. I'm a partner in Diener, Scan, Milne, and Larson. I've spent most of my time in the court for which I seek, so I feel that I'm very well qualified for that. Susan Scan.
Good morning. My name is Ken Pollack. Thank you for the opportunity to come and visit with you this morning. Currently, I serve as a district judge in the state of Nevada. My current assignment is in the family division of the district court. I've been serving as a district judge since 2008. Prior to that, I was an attorney. I've been a licensed attorney for in excess of 18 years. In that 18 years, I also served 11 of those as an arbitrator, where I heard in excess of 400 cases. I also previously served as an alternate municipal court judge, in which I heard over 2,800 cases. In the last year, I've probably heard, in terms of motions, about 2,000 motions. I've heard about 200 trials in the last year. In terms of my legal practice, other than being an active judge, my practice, I handle just about every aspect of the law with the exception of probate and bankruptcy. Prior to becoming a judge, my practice focused on complex civil litigation. I did 10 years in construction defect litigation and other multi-party high-value cases. In construction defect, you learn the value of case management and alternate methods of handling cases. We had cases that had documents in excess of 1 million pages. So you learn how to organize and analyze information very quickly and very accurately. Prior to moving to Nevada, I came from California. I practiced in Los Angeles County. I went to undergraduate at the University of California, San Diego, law school at the University of San Diego. And we look forward to answering your questions. Thank you, Ken Pollack.
We're going to go ahead and start off with the panel member questions. My name is Nick Starling. We're going to go ahead and start off with Mike Mazur on the end. So, Mike.
Thank you. There we go. Now the mic's on. This question is for both candidates. How do you see the impact of the mandatory electronic filing system in impacting the access to justice for all individuals?
Okay. Well, the mandatory e-filing, the only thing really different about it is making it mandatory. In complex litigation, the attorneys in that area have been using e-filing and WizNet for over 10 years. We were the prototypes and guinea pigs for developing the system. Unfortunately, with the rollout that we've had on February 1st, we've had some hiccups. It does work once we get through the process and get the cases out of the queue. From the bench's side, it's a wonderful tool because we have the documents already scanned on our computer. We can pull up the image almost immediately. In terms of service, we eliminate some of the service problems where people are claiming they don't get the documents because once it's filed, a copy, as long as you do the e-file and serve option, automatically get served on the opposing party by Wisnet, so we know that they actually did receive a copy, and there's an audit trail that shows that when the document was sent. And I believe, if I'm going back in my memory bank, there's even an audit trail that the document, the email that contains the file, was opened, so that we can actually determine whether somebody received that file or not. We no longer have what I refer to as sewer service, where someone files the certificate of mailing but never mails the document and then tries to get a cheap win by not having their opponent know that this document is out there. So I think in terms of access to justice, it's a wonderful tool. The bench has added one thing that didn't exist to e-file, which is the ability for litigants to actually come to the courthouse and e-file it for free. So funds aren't even a problem. You can either do it as attorneys from your office and pay the small filing fee that Wisnet charges for the convenience of not having to come to the courthouse, not having to pay runners to stand in line. It's done instantly. You can file things after hours easily. So it is a wonderful benefit, and the increase of technology does aid the court.
Susan Scan, I'll speak from the practitioner's point of view. I've been using e-filing in bankruptcy court and federal court for years, and it's absolutely seamless. It doesn't cost anybody anything. You file it, it's in there immediately, you get a receipt. We're having some significant startup problems in state court. Things may be filed or put into the queue, but you don't get a file stamp copy for a couple of days. And hopefully that is going to get better. There's a cost associated with every single filing that you do. So far, the system to process those costs has not really been set up. People are using credit cards, and you hear stories about lawyers running around through the office trying to find enough credit cards to file this thing, because the cash deposit system doesn't work yet. And now that it is mandatory, it creates real problems. The e-filing down at the courthouse is, for ProPers, is a good thing because that's free, but there's only one, and so there'll be a line there. And in terms of costs of runners, that's really not eliminated because the courts still want courtesy copies. And in district court, if you're filing long documents, and I sympathize with the judges totally, you don't want to have to read that on the screen. It's available, but the attorneys routinely provide them because that allows the judges to do a better job. So e-filing is the wave of the future. It is definitely an advantage, but the system that we have right now has got problems that really need to be worked out. And I wanted to mention too, I didn't mention in my bio, I've been an alternate municipal court judge for 30 years since 1980. So I've sat on many, many cases. I'm also an arbitrator in the state annexed arbitration program. I've been doing that for 3 or 4 years, so I've been sitting on arbitrations there. So I have substantial experience actually being on the bench.
Great, thank you.
I have a question for both candidates. In terms of making a record in a civil court, are you more inclined to use a live certified court reporter or the transcripts that are heavily delayed by using a tape recording system?
At this point in time, I've experienced both, and having a court reporter there is an advantage. You can pay a small fee. You know you'll be able to get your transcript when the time comes. We've dealt with, I think, bankruptcy court primarily uses the ones where you have to get it's only tape. There isn't a live person there, although somebody manages it. So there's a definite advantage to having a court reporter who's present in the room. Plus, I think it probably improves the quality of the transcript because somebody can actually hear it, and there may be some residual ability to know what a sound is that may not have come through completely.